trial hearings before the case starts in June 10th. The defense is asking for a number of motions, mostly dealing with what the prosecution hasn't provided as of yet. Let's put you right back in the hearing.
The retreat at Twin Lakes called emergency services upon hearing some part of the events of February 26th. One of the residents called and was connected fairly early in the sequence of events. After the event began, but before the shot was fired. So there's about 40 seconds of recorded 911 call before the shot is heard. During that time period, during that 40 seconds, there are a number of what have been characterized as screams or cries for help that are heard clearly in the background. That recording was played for Trayvon Martin's father, Tracy Martin, about February 28th by the Sanford Police Department. It was not made available to the general public. Testimony from police officers were that when Mr. Martin heard the recording that contained the screams and the shot and was asked by the investigator, "Is that your son?" he said no. Fast forward a couple of weeks or so, there was an event where, over the objection of law enforcement, the mayor, with the agreement apparently of the city manager, assembled Mr. Martin's family and council and played that recording as well as some others. Around March 17th, I believe. Law enforcement was not present, and all of the family members and council were in the room together hearing these calls, all but for Tracy Martin hearing them for the first time. There were various reports about what was on the recording. Frankly, statements made that are absolutely forensically untrue. For example, 2 shots as opposed to 1. We know that just didn't happen. And some other observations. However, in response to Sanford police investigators saying that Mr. Martin did not identify his son's voice when he heard those cries for help, it was reported in the newspaper.
You're looking at Defense Attorney Don West. He's making a request regarding certain materials, including 911 calls that he says were played for the Martin family, and on those 911 calls, screams were heard for help. This was during the altercation between Trayvon Martin and George Zimmerman. His claim, the defense's claim, is that Tracy Martin initially said that wasn't his son, but there's a lot more to come from that. Keep it right here on H.O.
Mr. Martin.
The 911 call is with an expert to be cleaned up or enhanced.
If possible, yes, Your Honor, if possible.
And it is not going to be edited, is that correct?
They will do whatever work they do, the experts do regarding that, and obviously they have been listed, the experts have been listed by defense, such as the defense has their own experts. We don't know what their experts are, but that's been provided.
So a cleaned up, edited, or enhanced version of that 911 call has not been provided to anyone?
That is correct, other than the experts are doing whatever they're doing.
Other than the experts?
Yes, Your Honor.
And when you get your cleaned up, enhanced, and/or edited version, you will provide a copy to the defense within 24 hours. If the defense has their own experts that are trying to do the same, they will provide that information or report to the state within 24 hours of receipt.
Yes, Your Honor. We believe, just for the record is clear, there's 2 experts that have already been, the reports have been provided to the defense and they've already been deposed. So there's 1 additional expert, 2 additional experts.
Your Honor, with all respect, that's secondary and not really related to the issue as to what happened last March. The statement that was reported was attributed to Mr. Crump that there was a cleaned up copy that Mr. Martin heard. Apparently the state has not inquired of Mr. Crump whether or not that copy exists, or what did he mean by that when he said to the paper, there's a cleaned up copy that Mr. Martin has listened to. That's what I'm trying to get to the bottom of. The state has been aware of this for some time. If the state won't inquire of Mr. Crump, perhaps the court will, just to find out.
No, you have in front of the 50CA the motion to determine whether or not they're going to allow you to depose Mr. Crump. I have ruled on that issue. We will await their response. So you've been told by counsel that they have not provided to anyone a cleaned up, edited, and/or enhanced version of the 911 tape. The copy of the tapes are in the hands of experts for both the state and the defense to try to do that. If reports are received that have not already been sent to the other side, they will be provided within 24 hours. Is there anything else regarding this demand for specific discovery?
Only that we would ask the court to direct the state to inquire of Mr. Crump whether there is in fact a cleaned up recording that was available to Mr. Martin in mid-March. And
The state has already indicated that they have not provided a cleaned up, enhanced, or edited copy to anyone, and the only copy that they've given is to the experts to try to do so.
Yes, Your Honor. In fact, when this took place in mid-March, Mr. Delarionda's office was not yet appointed. The question is, did Mr. Crump have a cleaned up tape that he played for Tracy Martin? And I'm asking the court to ask Mr. Delarionda to find that out.
If you'll read the rules that I provided you in the front, that once the court rules, there will not be argument about the issue with the court. So as far as I'm concerned, that issue is concluded.
Thank you, Your Honor.
Thank you. The next one is defendant's unredacted motion to allow.
Oh, I think I just heard a smackdown of the defense of George Zimmerman.
Sort of side of things. The 776.032 allows for an immunity to be requested or asserted by the defense. Traditionally, that is done pursuant to 3190, which allows for a pretrial determination of those issues. And for efficiency, and quite honestly, in most cases, it makes sense. Why go to a trial if you can address and resolve the issue ahead of time? Because, as I've mentioned to you at a previous court hearing, the unique nature of this case, and because of the way we've decided to handle it, that we would much rather have a jury address the issue of criminal liability or lack thereof. Having said that, there is nothing in the case law, there is nothing in the statute, and there's nothing in the rules that would suggest that that issue has to be heard pre-trial, or that the defense would need to preview any strategy that it might have to the court or the state. There are two concerns with that, so if I can address them, I think the state will have their response. The two concerns are this. Is one of the parties somehow prejudiced by the idea that the defense would maintain the right to present that argument to you during the trial or at the end of the trial? Here are the two concerns. Procedurally, generally speaking, under a motion to dismiss, we carry the burden to prove, preponderance of the evidence that immunity should be granted because we've proven that Mr. Zimmerman acted in self-defense and was reasonable in doing so. I know you're well aware of the standard. I've read some of your orders in that regard. So the procedure is an issue. However, since this is a hearing that is solely for this court to decide, and you would only decide it at the end of the presentation. If we were to do this, then we were to do it certainly not at the end of the state's case, and at the end of the defense case, and quite honestly, it would properly be at the end of the state's rebuttal case. We might come to you and say, we'd like you to consider 776.032 immunity. So do what you can.
Those are the might things, and I'm not arguing with you on those, but I understand the state's reasoning because of potential 3.850 issues. I think that there are certain questions that I will limit. If you have an objection to the question, I will hear your objection at the time that I ask it.
May I respond to that? Okay. This concern over whether or not I am properly and effectively representing Mrs. Zimmerman is an issue that this court both can and usually does address at the end of the trial. So, here's my response to that. Not to preempt my client's right not to testify, not to preview his strategy today. At the end of the...
I'm not previewing a strategy.
Well,
I'm going over what has been done,
Okay,
not what's going to happen in the future.
okay. And just to finalize,
I will allow you to object and hear your
Okay.
objections and may not ask the question.
to the extent that the cert has a concern over my ability to represent my client on appellate issue review, I think this court can address that not now, but you can address it at the end of the trial when you ask Mrs. Zimmerman, example, Mrs. Zimmerman, you have continued to waive. Do you understand? And you would go through that
I
inquiry. Or
haven't
you,
heard him waive.
I'm sorry?
I haven't heard
No,
him waive.
but you can ask him that at the end of the trial.
Well, in all the criminal trials that I have conducted, I do ask the defense before and during the trial whether or not there are any other witnesses that you want your attorney to call, were there any other issues that you wanted your attorney to bring up? Are you aware that your attorney is arguing that to the jury a lesser included offense and is admitting to that? Those types of issues, that they'll come up later that any defendant says, I never knew that.
Okay.
So that's the type of issues, the questions that I'm going
Then I apologize because I may be believing that there's more to this than there is. Is your inquiry?
Object, feel free to object.
Is your inquiry going to be limited to whether or not Mr. Zimmerman has not asserted his pre-trial right to an immunity hearing?
Absolutely.
I apologize. I've spoken too long and preemptively. So
That's okay.
as to that issue, if I could have just a moment.
Yes, you may.
We're going to hear it, and we're going to hear in front of the entire world. We're going to hear what George Zimmerman wants to do. He doesn't want that to happen because his strategy is out there for all of us to see. Now, you know what the judge just said? Hey, just come up to the stand. I'm going to tell you exactly what I'm going to ask him. Stop mincing words. I'll get right to it. And Zimmerman, you see how concerned he is. This is the biggest
Oh, she's
decision.
taking a break. Is that what she just said?
I bet I know why.